Well, Eric and Jon, thanks for joining us today to talk about the SEC and some of the new changes. To get right into it, maybe quick background for Eric and Jon, and then we can get right into the questions. So Eric, it'd be great if you can give us a quick background on you.
Sure, Andy. Well, thanks for having me. Eric Forni, I'm a partner in DLA Piper's Boston office. I spent about 15 years in the federal government as an SEC enforcement and trial attorney and as a federal prosecutor. And I've been at DLA for close to 16 months doing all sorts of work, mostly SEC-related defense or advice on the same.
Awesome. Jon?
And I'm Jon Venick. I'm a corporate M&A partner here at DLA Piper's New York office. I've been with the firm since 2009, during which time I've primarily focused on my practice on representing public companies. Like I said earlier, particular emphasis on M&A, but really, transcends all of public company needs, whether it's reporting or governance or just day-to-day operations. So it's a great team here. Thanks for inviting me, Andy.
Absolutely. So to get into it, I mean, one of the things of our audience is we have people that know the SEC, we have people that know privacy and security, but part of what's happening is this convergence. And so, Eric, maybe you can kind of give us an overview of the primary function of the SEC and then how does it enforce securities laws?
Sure. Well, SEC is obviously a federal agency that is designed to regulate the federal securities markets. And for the SEC, that means protecting investors, helping to facilitate capital formation, and to promote fair and efficient markets. And when that comes to regulation, it's anything that could impact investors that investors may want to know about, whether it's cybersecurity or otherwise.
And Jon, what's been your experience there?
Yeah, I mean, I think the SEC could be very collaborative with companies. Obviously, they are charged with rolling out, among other things, regulations like the topic that we're talking about today in the cyber industry, trying to streamline disclosure and ultimately, protection for the investors. So I think, that these types of rule changes are very good opportunity for public companies to use that as a catalyst to take a strong look inward and evaluate if their disclosure controls and procedures and their overall governance are adequate, or if they need to be adjusted to meet the new regime that we'll get into.
Yep. And then from an enforcement standpoint, I mean, Eric, you were on the front line of that. How are those laws enforced generally by the SEC?
Yeah, sure. And just taking a really quick step back, there's primarily two federal acts that the SEC enforces when it comes to the typical publicly traded company, and that's the Securities Act of 1933 and the Securities Exchange Act of 1934. And I won't get into the details of those here, but one act is really about the registration of the offer and sale of securities from the company to investors. The other act is really about secondary transactions and what you can know and learn about a company to make informed decisions. And that's really where cybersecurity issues often come into play, where companies are filing their quarterly or annual reports. And so the SEC enforces the laws by both having divisions that oversee filings and review them for accuracy and to ensure they're consistent with form and expectation. And then enforcement, if there's issues worthy of investigating, they'll send subpoenas, they'll conduct investigations, interview folks, review documents, and decide whether they believe there's a violation of the federal securities laws. If so, they'll recommend enforcement action to the commission, and if it's approved, it's filed as typically a civil action that proceeds like any other litigation with federal court.
That's great. And so, I am the not securities lawyer here, but I think one thing that is confusing to people in my space is, generally speaking, with some exceptions, you both know better than I, that the federal securities laws aren't imposing control requirements. They're much more focused on disclosure requirements, with Sarbanes-Oxley for financial reporting being an exception. But I guess that it'd be helpful, Jon, to kind of hear your perspective on how companies should be thinking about this, and more importantly, maybe how people who aren't as familiar with the federal securities laws and requirements should be thinking about it, because to me, the surprise was it's much more about disclosure than it is necessarily the controls, although at times it's both.
Yeah, no, I think I agree with you, Andy. I think in times it is both. And I think, like I said before, I think this is when these types of, rule changes come into play, I think it's a great opportunity for companies to look inward and, say, okay, here's the minimum disclosure requirements, et cetera. what does that mean for my governance? Kind of where do I reside in the overall spectrum? And what do I need to do to either get better? Am I ahead of the curve? That sort of thing. And so I think it's easy to say, okay, I have to disclose incidents, or on an annualized basis, so we'll get into, I have to disclose, the framework that the registrant has in place. But if you have the disclosure without the governance to back it up, you're really setting yourself up for a pitfall. And so, again, it comes back to now is a good time for companies to take advantage of the rule change and the runway that the SEC gave until December in order to get in line, so to speak.
Yep. And look, I think another thing that happens, and we all have our jargon, is, certainly privacy and security are no exception. We hear K, we hear Q, we hear 8K. Maybe you could just give, Eric, if you want to start, what are the main filings? Because, again, public disclosure is certainly a core part of this. What are the main filings that companies have to do that are implicated by the cyber rule? And then, John, maybe you can weigh in as someone who's had to draft a bunch of them, what that means for a company practically.
Sure. Yeah, the main filings are quarterly reports, which every 3 months you file your what's called a periodic report, disclosing other things, your quarterly financial statements, and management's discussion about essentially how you're doing and risk factors and related information. That's a 10Q, Q meaning quarterly. The 10K is an annual report, which consolidates the entire year's worth of information, file that once a year. And then an 8K, which is really the primary filing we'll probably talk about today, is essentially, of course, either quarterly or annual, but are required on an ad hoc basis to disclose material developments in a company. And this is, just to be clear, this is all true for domestic companies. There's similar type filings with different names for foreign private issuers, but I think today we'll primarily focus on U.S.-based issuers.
Yeah. Exactly. And John, having, being the one who has to draft some of that stuff, what's it like, and how does it sort of impact companies when they're having to make these filings?
Yeah, no, it's a great question, Andy. I think, I'll take it kind of the reverse order somewhat of what Eric did. I think, I always look at the 10K as a great chance for a company to take a holistic view of its business and operations and its various segments, and disclose things among other things like their risk factors. So what are material risks to the investor with respect to the business and operations of the registrant? Here, as it relates to cyber, that before the new rule changes, that's kind of where things started and stopped, right? And now, and again, we'll get into this, but what the SEC has done is they've streamlined the type of disclosure that needs to be made on an annualized basis with respect to the governance surrounding cyber and whatnot. I would expect the 10Q, absent a material change within the quarter, won't have a ton of discussion around cyber-related incidents or governance or whatnot. Hopefully, there haven't been material changes for a registrant during that particular quarter. The 8K, I think, is very interesting because before these new rule changes, it was somewhat of a wild west, if you will, as it related to cyber disclosure. You had a lot of everything hinged upon materiality, right? And you had a lot of differing interpretations as to what's material to an aggregate company and what is not, right? It's an extremely subjective standard. While materiality is still very much a part of the analysis, with the SEC coming out and saying, okay, there's a whole new item within 8K as it relates to cyber incidents or a series of related incidents. I think, again, while there still is a materiality, it really is forcing the issue and forcing the registrants to be a bit more conservative, I would say, because again, you don't want to find yourself on the wrong side of now an explicit disclosure obligation.
Yep. And Eric, what's your sort of take on that?
Well, I agree with John. The way in which registrants, publicly traded companies, dealt with cyber-related disclosures before was to use an item on an 8K, typically item 801, which basically provided a mechanism to provide other information that the registrant may believe is material. But the reality is you can benchmark this. Obviously, there was, and Andy, of course, you lived through many of this. There's way more cyber security at public companies. And just by the sheer number of cybersecurity incidents, you would have expected if all companies were disclosing them, you'd see a significant number of 8Ks filed. Now, in fairness, all those companies, there wasn't an express obligation to do so. Some companies chose to do so for certain really significant cybersecurity incidents or related events under the prior regime. Now, to Jon's point, you have no choice. You have a express obligation to disclose a material cybersecurity incident. It still relates to the question of what's material. There'll be some gray areas there, and I'm sure the SEC will be critical of companies that choose to decide the incident is immaterial, and the SEC will probably decide with the benefit of hindsight it was material. So those are going to be some of the thorny issues that maybe we can talk through in a bit. But I agree with Jon that the landscape's changed considerably, or will change when the rules become effective on December 18th.
And look, the past obviously was there'd been guidance that wasn't binding. Obviously, there'd been companies, to your point, doing things not that weren't as expressly mandated as they are now. Maybe, Eric, if you want to give kind of a summary of the state of play prior to the rule getting enacted, sure. Obviously not effective yet, but kind of, how companies were thinking about it, and then we can get into sort of how it's changed.
Sure. So before the rule was passed earlier this year, which will, as we've said, will be effective at least in part on December 18th, there was not an express obligation for public companies to disclose a material cybersecurity incident. There was, however, always an obligation for companies to make disclosures that ensures that whatever they are required to disclose is not materially misleading. So you can imagine a scenario where omitting a cybersecurity incident could make a risk factor of materially misleading, or make management discussion and analysis materially misleading. So what the SEC has said before is, even though we can't require you, public company, to disclose material cybersecurity incidents, we will enforce the failure to do so if we think the failure has rendered other things you've said materially misleading. And even more to the point, even when companies thought they were doing the right thing and frankly volunteering a cybersecurity incident disclosure, if the SEC said, thanks for volunteering, but we think you only told half the truth, that would also provide a tool for potential enforcement consequences. So before, the SEC just said, read everything very carefully in your filings, risk factors, management discussion and analysis, notes of financial statements, everything you're saying. And frankly, even if it's not in the filing itself, on your website, otherwise available to investors, you need to ensure that it is not in any way, shape, or form materially misleading based on known cybersecurity incidents.
Got it. And Jon, again, as someone who's had to draft this stuff before and make calls on 8Ks, like what practically speaking are companies thinking about when they have been going through that process?
Yeah, so with respect to the incident disclosure, so the 8K disclosure, Andy, I think in a way by mandating that companies make this disclosure under a new item in Form 8K, I think, for lack of a better word, it destigmatized the disclosure of cyber incidents, right? I think prior to this new regime, people were very hesitant, and I don't have the numbers in front of me, but there weren't all that many filings as compared to what I would imagine are, a lot of cyber intrusions and exfiltrations and all the stuff that you deal with on a day-to-day basis. Now, because it is mandatory, I think that my expectation is that investors perhaps will view the disclosure as a bit more, routine, and something that is, again, mandatory and obligated of public companies, and therefore hopefully encourage, additional disclosure where perhaps, previously, again, materiality still is a big part of the equation, but where perhaps the subjectivity would have led a registrant to not make the filing voluntarily, as Eric mentioned.
And look, we saw the same thing. I mean, the data breach laws have been around now for 20 years regarding individuals. And, we certainly saw that in the beginning in 2003 for a while when, you didn't want to be the one that had to do it. And now, they're pretty routine. And so I think there's definitely more of a bias from a stigma perspective, at least, with the data breach notification requirements, putting the SEC requirements aside to be transparent, because there's just not as much downside. And I think you're right. You probably will see that the same way with the 8Ks, whether they're actually legally required or not. The calculus of what's the impact of doing it probably will change as a result of the changes in the rules. So maybe let's get into that. So we, prior to this point, we didn't have, a directly mandated requirement the way we do now. There's obviously event requirement disclosures and there's also sort of other disclosures. But let's kind of go through, Eric, from your perspective, what did the new rule do, and what's changed?
Sure. So the way I look at the new rules, it just added more obligations on public companies. It hasn't superseded any of the prior guidance, at least in any significant way. So notwithstanding whatever the new rules require, which I'll talk about momentarily, public companies still need to ensure that when they're saying things and risk factors, management discussions and analysis and the like, that what they're saying is not materially misleading, and it should be updated to incorporate cybersecurity related incidents or similar type issues. Now, though, starting December 18th, public companies need to disclose material cybersecurity incidents within 4 business days of determining without unreasonable delay that those incidents are material. And to be sure, the SEC has said it's not just the company's own incidents, but it could be third-party incidents, to the extent those incidents may jeopardize the company's information systems. And so it's a pretty broad scope, especially given the number of companies nowadays that rely on vendors and suppliers for at least some housing of their information system related information. And so going forward, it will be incumbent upon companies to now have a process in place to be timely escalating incidents for review for potential prompt disclosure. The other really interesting part of the rule that I think is probably the one that is the most opaque at the moment is the SEC has said, if you don't have all of the information at the time you need to make a 8K disclosure, you have to file an amended 8K to disclose the things that you would have disclosed earlier had you known it. And I think that presents some really interesting challenges for companies to think about what is the trigger at that point and how many amendments do you have to file and when does it stop?
Okay. And on that point, we'll get into the risk factor disclosures, and I want to give Jon a chance to weigh in on this, but I think the 2 things that are important is, one, there are 2 pieces of time that we're talking about here, right? There's the unreasonable delay component, and then there's the 4 business days after you've made the determination. And so it isn't 4 business days total. There are 2 sort of pieces to that.
Right.
And Jon, maybe you can cover this. Like one thing that was a little bit surprising, I'll say, to me as the non-SEC lawyer, is there's not really a general duty to 8K every material event. And I think that was something I kind of went into this thinking is like, okay, there's just a general requirement. There's really sort of not, unless you're going to tell me I'm wrong about that, but maybe help people understand, like, this isn't, the 8K process isn't just, you have to disclose every material event. There's certain things you have to disclose and certain things you don't. Because I do think in my little corner of the world, people have a bit of a misunderstanding about that.
Yeah, no, Andy, I mean, that's an excellent observation. I mean, it prior to, this regime, really the materiality of disclosure centered around things outside of the ordinary course, or such as entry into a material definitive agreement or something like that you don't do day in, day out as a public company. But this really, I think, shined the light on the importance of cybersecurity, from a registrant's perspective, from a macroeconomic perspective, and the potential, downstream impacts to investors and just, the general public. So it really does shine a light on the importance of cybersecurity and the need to have the governance to support it.
Yeah. And that's kind of the point, right? I think that, again, there's this sort of, I certainly had the misunderstanding, like, this isn't normal, right? I mean, This is this isn't a normal thing for the SEC to do. And there's certain things you have to 8K, and it's not everything, right? And so I think as cyber professionals, we need to understand that this is getting a lot of unique attention that isn't the normal course, even for the SEC. And so that sort of frames how we have to think about the 8K piece, right? And I think that bleeds over into the risk factors as well, even though I know those are very different things. But maybe turning to that, Eric, to tell us from a risk factor perspective, how does the new rule, is it as big a change as what we're talking about with the 8K, or is it maybe more highlighting what the SEC sort of already expected without an explicit requirement, and companies may have sort of already been doing?
Yeah, I think it's the latter, although easy for me to say, and Jon may disagree, but I think that, well, 2 things. One is the generic risk factor obligations are still incumbent upon public companies. You have to disclose material risks that affect your business. Those risks may relate to the risk of cybersecurity incidents, vulnerabilities being exploited, or something similar. The difference now is there's express obligations to tell investors what management and the board is doing to oversee and manage risk from cybersecurity threats. My view, I'm fortunate here at DLA to work with firms that companies that are relatively sophisticated. They've already been doing this, right? But if you're a new company, maybe you haven't really been thinking about who at the board level is responsible. Is this part of our audit committee charter? Do we need a new subcommittee? Do we have a disclosure committee charter? Do we have an incident response plan that clearly escalates incidents up so that management becomes aware of them and can manage them? I think most companies were doing that, but not all of them. And now if you're not a company that has been doing that, the SEC is basically saying now you need to be doing that. You need to be disclosing it to investors. Now, to be clear, the rule doesn't say you have to do it. It says tell us what you're doing. So you could choose to say we're doing nothing. I don't think anyone advise their clients to take that position, though.
Yeah. Yep. That might create some work for our Delaware litigators if that's what we do. Right. Ron Brown would be rather busy. But Jon, what's your take on that?
Yeah, it's interesting. Eric has used now a couple of times the word escalate, and I think it's very important, right, because of the implications behind it, which is a lot of times, the first individual within an organization that finds out about a breach or an exfiltration or whatever the case may be are kind of people on the front lines, right? So it's not the CEO, it's not the general counsel. And so I think the practical implications of these rules are monumentous, right? Because the risk here, as I see it, are companies, some companies have already disclosed historically what they do to mitigate this risk, because again, it's a very critical aspect for, all companies, public or private. But just saying that you do something and not actually taking the time to put in place the tools needed to, escalate these internally and have the primary decision makers within the organization alerted of, things that they might deem not material and therefore not disclosable, is not a overnight process. And so I think there's a large practical implication to these rules too.
Yeah, and look, I think that's where, and today's topic isn't the Delaware implications under Caremark, but you can look at that and sort of say, okay, if you look at the classic Caremark claim, the first prong is having the right information systems in place to actually understand your mission critical red flags using that language. And so while it doesn't seem like to me, the SEC's come in and said, hey, here's how you have to build your information systems. They're just basically saying, here's the disclosure you need. And, the back end of that is you do have to have the right information systems to actually capture the events and the risks that you need to disclose. Right. And, Eric, I don't know, your view is particularly interesting here, given that you were the one kind of making enforcement decisions. Like it doesn't seem like the SEC to me has come in and said, here's the 10 things you need to do. They're just saying, this is the disclosure we want, you company better figure it out.
I couldn't agree more. And I guess, so two pieces to that. One is, I think sometimes there's a misunderstanding when you think about SEC enforcement actions and to the extent they concern cybersecurity, what they really concern. They do not concern the SEC claiming that companies did something wrong because they had a cybersecurity incident. I think even the SEC will understand that the companies are victims in those when that happens, right? The enforcement action is actually concerned exactly what Jon said, which is, look, we feel badly for you. You had an incident, but when your CEO or CFO or general counsel told the market about it, they didn't tell the market all the relevant information about it because the person on the front line knew more or even worse, something different than what the CEO said. And that is a issue in internal disclosure controls and procedures. And when you look at some of the enforcement actions to date, they weren't about the cybersecurity incident in and of itself. They were about the failure to escalate and timely escalate all the information that's relevant for what the SEC views as relevant to investors. The other piece is the SEC is never going to prescribe exactly what the controls ought to be. They're going to say they should be reasonably designed to do the things we want you to do, which is make prompt disclosures to investors and to minimize the risks of cybersecurity incidents. So it does give companies flexibility. Reasonableness is sort of an objective standard, reasonably prudent company standard. So companies can do it differently. There's not one size fits all, but there needs to be some sort of repeatable process that you can point to if the SEC ever asks, what do you do in these circumstances?
Yeah. And look, people that do what, I do on a daily basis are much more used to, here's the control framework, here's the things you have to do, go do it, right? And I think being compliant, if you can ever be compliant, fully compliant, which I think is hard for any company to do in every area, right? That's not what the SEC is gearing these rules towards, right? It's having the right information systems to understand the systems and the risks, and then having the right escalation to either make the call to say, this is an event we have to disclose, or this is something we need to cover in a risk factor, right? And again, for my world, people are much more comfortable with compliance rather than, information systems, building information systems all the time and building escalation, right? It's not that people on the cyber side can't do that, but, that's not always the focus. And I think that's going to be one of the things that'll be interesting to see how it evolves over time, because it is really saying to companies, this is a three-prong approach, not just based on compliance, right? Because compliance alone doesn't build out information systems necessarily, and it doesn't build out escalation.
Mm-hmm. Totally agree.
Yep. So let's maybe move to practical takeaways, and I'll go first so you guys can correct me if I'm wrong. But, one of my takeaways is really the fact that cyber is getting, called out as an event, right? I mean, one of the takeaways for again, the cyber people and the privacy people is there's always been risk factor requirements and disclosures, and to the extent that, I think even if you didn't have a SEC rule saying you have to disclose particular things about cyber, to the extent it mattered for your company, you were probably making some form of disclosure already. What is different is it's now mandated in new ways for the risk factors, but more importantly, again, you have this very, kind of unique event requirement for disclosure that isn't the norm. And I think, again, people that do what I do really need to understand, like, that is, important to understand the context when you're looking at these 8K rules. It's not like every material thing gets disclosed, right? And so I think that's the takeaway for, from the cyber side is this is a heightened issue for the SEC, is shown by the fact that it has been selected for, 8K disclosure. So, assuming I didn't totally screw that up, I'll turn it over to Eric for his takeaways and then Jon's takeaways.
No, I completely agree. And I think part of what you're saying, Andy, maybe entirely what you're saying, is it's about preparedness at this point. I think the biggest takeaway for me is, yes, to your point, the SEC finds it's very important. They've highlighted it. They've passed in a rule. There's probably going to be enforcement consequences now. But there's always a heightened focus on enforcement when a rule is passed to demonstrate that they really care about it. But just about preparedness, I wouldn't expect that in the moment you can make a real easy determination on whether an incident's material, or even confidently signing 8K unless you know that you have a process to escalate. So I think the biggest takeaway now's the time to get your infrastructure ready, or even if you think it's ready, to test it, to make sure that when it's actually go time, because unfortunately all companies are going to experience some kind of cybersecurity incident, hopefully immaterial for all of them, but in the near future, that you know what to expect when the time comes.
Jon, what about you? What are your practical takeaways for companies?
Yeah, I think, look, as I said before, I think this is obviously a big rule change, and it's a time to really look inward. I think that the companies that don't take the right steps right now in order to remedy their internal governance are going to fall into two buckets that are going to have kind of, liability coming out of this. It's either going to be the company that really doesn't do enough given their nexus to, cybersecurity and whatnot, or it's the company that overpromises and underdelivers, right? Because in the 10K disclosures we talked about, the SEC is forcing companies to say, here's what we do. And if you don't actually do it, or you don't have the framework in place to escalate, and evaluate internally, that's a big no-no. And so I think the practical takeaway is, obviously it takes time, it takes money to build out roles internally, to do the training, to adopt the disclosure, policies and all the ancillary functions that go along with it. But now is the time, right? The SEC has given very special treatment to the cyber rules here, as you pointed out. And I think public companies would be really should take that to heart and take action.
Yeah, no, I think that's exactly right. And look, it's at some level we're kind of moving into a world where with cyber we've been with the Federal Trade Commission, or FTC, which is a lot of statements are used against companies, and there's not a public filing requirement with the FTC. So I think we are moving into that, and how do you ensure those statements are accurate? What are the processes you need around it? We've dealt with that, previously with the FTC, and I think we're definitely moving there with the SEC. So look, I really appreciate the time and the insights, and thank you, Eric. Thank you, Jon. And I know we'll be talking to you again.
Thanks for having us.
Thanks, Andy.
Thank you.